Hi, everyone. Welcome. We'll be starting in about 1 minute to give everybody a chance to join. Hello, everybody, and welcome. Can everybody hear me, Stuart? I think you can hear. Okay, good. Hi, I am Jen Reynolds. I'm a professor and associate dean of faculty research and programs at the University of Oregon School of Law. It's my pleasure to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspective series brings the work of our law school faculty to our colleagues, our students, our alumni, and the broader public. Today, I've asked two of our constitutional law professors to talk with us about the staggering revelations of the past week. And side note, although these are revelations that are indeed staggering, it's not like they're a complete blindside. We've been seeing changes for years in the broader landscape around voting, around the composition of the judiciary, around state rules curtailing reproductive rights, around political polarization, just to name a few. But back to this week. As many of you know, this past December, the Supreme Court heard arguments in the matter of Dobbs v. Jackson Women's Health Organization, a case about the constitutionality of a 2018 Mississippi law banning abortion after 15 weeks of pregnancy. Now, well-established and decades-old Supreme Court precedent, Roe v. Wade, Planned Parenthood v. Casey, would seem to preclude Mississippi's ability to enforce such a law, but it was clear in December that things may be heading in a different direction. For those who don't know, after the court hears arguments on a case, they meet to discuss the case, and then they take a vote on where everyone stands. If there's a majority, one of the justices gets appointed to write a draft majority opinion. Drafts get circulated, they may get adjusted. Justices who aren't with the majority may write separate concurrences and dissents. Sometimes justices will change their mind about whether to join a particular opinion. Typically, all of this work happens outside public view, and that's part of what made this week's events all the more stunning. On Monday night, a draft of the Supreme Court's majority opinion in the Dobbs case was posted on Politico, a website. The draft opinion, which was labeled First Draft, was authored by Justice Samuel Alito and was circulated on February 10th, 2022. Although we can't tell from the draft opinion who else was in the majority, Politico reported a source claiming that Gorsuch, Thomas, Kavanaugh, and Barrett all voted with Alito in the December conference. That was on Monday. Then on Tuesday, Chief Justice Roberts admitted that the document was authentic, though he emphasized that it was a draft. The Chief Justice also called the leak a betrayal and a breach of trust, promising an investigation. Like many of you, I have read the draft opinion, and I have followed the coverage of these events obsessively over the past week. Some people are focused on the draft and others on the leak. Frankly, I'm pretty concerned about both. So I'm grateful to have with me today two incredible people from our faculty, both constitutional law professors and scholars, Garrett Epps and Stuart Chin. In the interest of time, I'm going to skip the customary introductions. You can read all about these two on our faculty website. The plan today is for Garrett to provide for us an overview of the draft opinion and then talk about what stood out to him as particularly noteworthy. After that, Stuart will share his thoughts and reactions. Um, we also really want to hear from you. So we've reserved about half the time for your comments and questions. Please feel free to submit those through the Q&A function. Only the presenters and I can see those, so you can make them anonymous if you want. We're going to attempt to get to as many as we can during the hour. Professor Epps, we're grateful to have you here, and we will start with you. Oh, it looks like you're on mute.
I'll jump right into it. I'm not going to spend a lot of time on the leak for a couple of reasons. One is I'm not a court insider and I can't really speculate much about that. None of the theories that are circulating make any sense to me at all. And so I think probably someone did something irrational because this term has been such a zoo, really. The other thing is I wouldn't expect much from the Marshals investigation. It's a little bit like hearing that Inspector Clouseau has been called in to solve the mystery. The Marshals are wonderful. They once found my watch for me when I'd lost it, but they don't really have Bunk and McNulty, and I don't really anticipate they're going to be sweating a lot of suspects. As a very wise professor, not me, said in the New York Times yesterday, this isn't Scotland Yard. So let's jump into the opinion itself. There's a lot in it, and I will try to summarize it as fairly as I can, and then maybe in the time that I have remaining, pick it apart to some extent. But basically, what the Alito opinion says is the following. The Constitution doesn't mention abortion. Abortion is not touched on at all by any of the provisions, even implicitly. And so the question then has to be, according to this opinion, is there some long-standing tradition protecting a woman's right to choose abortion? And there isn't. This is, Justice Alito says none, zero, nothing. He just to make sure that you understand. It then says we have the right to abortion is based on two precedents of this court. Roe versus Wade and Planned Parenthood of Southeast Pennsylvania versus Casey. It says both opinions are poorly written and were egregiously wrong at the time they were decided and are thus not entitled to any consideration as a matter of stare decisis. It then launches into the issue sort of de novo and says abortion is different from any other right, enumerated or unenumerated, because it has an effect on life, on what the Roe opinion called potential life, and what Justice Alito is trying to work into the conversation, the term unborn human being, which would be a major change in the U.S. reports. Because it's unique, because it involves difficult questions, it should be decided by the political branches of the federal government and the representative legislatures of the states so that people can strike their own balance between rights and interests rather than have the court make that decision. What the court says, according to this opinion, is that the Constitution is neutral about abortion. It doesn't say it can't be permitted. It doesn't say it can be permitted. It's just neutral. It says, then goes on to say that looking at the reasons that have been advanced for a right to abortion, he says women have no need. This is stated as fact. Women have no need for abortion. Their lives are okay because there's health care that'll pay for pregnancy. There's an abortion. There's adoption if they want to put the children up. They can't be discriminated against because they're pregnant. There are laws about that. Beyond that, if women have relied on the availability of abortion as part of their ordering their lives, they were wrong to do that. Says that the Casey opinion said that women had relied on the right to abortion. Casey was wrong. Reliance and this is a very remarkable statement to me, but reliance, it says, is only involves property or economic interests. Otherwise, there's no such thing as reliance in the stare decisis calculation. So Roe and Casey are overturned. States may regulate abortion as long as they have a rational basis for doing so, and the opinion goes through a long paragraph of all the rational bases why abortion a legislature might want to restrict or ban abortion altogether. Everything seems to be on the table as a result of this opinion. There is no mention of any required constitutional exceptions. The words rape and incest do not appear in the opinion. The only mention of the health of pregnant women is in a statement that one reason to ban abortion is to protect the health of pregnant women. There's no constitutional requirement anymore, apparently, that an exception be provided. Seems to be no exception for first 6 weeks. It's up to the states completely. I will say a couple of things, and the first is that the court criticizes Roe and Casey. That part of the opinion, is perfectly well taken, and that critique of these two opinions has been shared by people across the spectrum. Roe was a very strange opinion. The court went far beyond the question presented, and has been criticized by many, many figures across the spectrum who can't be accused of being partisan or misogynistic or anything else. But interestingly enough, when Justice Alito lists the people who have criticized abortion, the eminent figures, it's an entirely white male list. There is no female scholar even referenced in the opinion there or elsewhere, which to me honestly seems like a calculated slap and extremely rude. In addition, the treatment of some very prominent previous justices is quite contemptuous. It's a little bit like in The Princess Bride when Vizzini says, Socrates, Aristotle, Plato, morons. He really just dismisses the ability of people like Sandra Day O'Connor and Anthony Kennedy, and says, basically there's a new sheriff in town. The study of history and tradition is something that I studied carefully, and there are a couple of things in that. This is an attempt at legal analysis, but it misstates the test. History and tradition is not the sole test for unenumerated rights. There's a panoply of them. The conservative project for years has been to restrict it only to rights that were already protected at the time the 14th Amendment was enacted, which raises the question of why we needed a 14th Amendment. But at any rate, even within that context, the history that's offered is extremely poor. It really basically what Justice Alito does is quote treatises by eminent writers on the common law from the 16th, 17th, and 18th centuries that sort of say actually that abortion is legal up until what was called quickening. But he says, yes, but they also disapproved of it. And that's all we need to do to know that there's no tradition of a right to abortion. And then he looks at state statutes in effect at the time of the framing of the 14th Amendment. And he says, well, not every state, actually some states allowed abortion up to quickening or something like viability. He said, but that doesn't mean they didn't think they could. They knew they had the power to ban it. And there's no explanation of how he knows what was in the mind. It's very poor originalism as far as I'm concerned. The common law authorities he relies on, Sir Matthew Hale and Blackstone and people of this sort, remember, they are writing about a common law in which a woman had no rights at all. A woman was basically the property of her father or husband. She had no right to own property, certainly no right to vote. She had no right to custody of her own children. She could be raped or beaten by her husband without any interference from the law. And so, looking to them as the sole source of tradition and really ignoring a fairly rich vein of women's history that has been written in the past 40 years about the ways in which abortion was tolerated or regulated in society is quite marked. And I'll go further. It's not really history. It's gibberish. It's motivated reasoning. It's what I call boys' rules history. You know, Sir Matthew Hale counts women who were midwives and participated in caring for pregnant women. Don't. They don't exist. Finally, the opinion says this opinion doesn't mean we're going to overrule a lot of other opinions about unenumerated rights. Abortion is different because of this human life thing, but its phrasing is very interesting. It says that the unenumerated rights that had been enunciated by the court before Roe, before 1973, are not in any danger. It's markedly silent about cases like Romer versus Evans, Lawrence versus Texas, and Obergefell that were decided after Roe. And it kind of reminds me of a statement that was made by the university administration back when the Matthew Knight Arena opened, and the faculty raised questions that it wasn't going to pay for itself and that academic funds would be diverted to pay for it. And the administration said that we promise the university community that academic funds will not be used to pay for this arena unless they are needed. And in essence, I think Alito assures us all that he will not be overruling Obergefell or Lawrence unless he has 5 votes. So the overall, this is the most, it's not unexpected that Roe would be overruled. There was some prospect that Chief Justice Roberts would find some middle ground in which they reaffirm Roe but somehow uphold the Mississippi statute. This is the most extreme version of the opinion that we could possibly have expected, and I think it raises, it may go through some editing before it becomes the opinion of the court, but it certainly should raise concerns about the direction of this new majority. I wish I had better news about that, and I think the news is quite bad if you're someone who believes in any of these unenumerated rights, and if you're someone who hopes the court will not lurch to the right in a highly partisan way. I will conclude by saying I vividly remember the day in 1992 when Casey was announced, and we had all expected that the court would overturn Roe in that opinion. And at the last minute, as you know, the court reaffirmed the essential holding of Roe, and the opinions and were very bitter. The separate opinions, the dissent by Scalia, which basically mocked Harry Blackmun and said, "You're going to die soon, and we're going to replace you with someone who will overturn Roe versus Wade." And after I read that opinion, I went to bed, and I don't think I slept the whole night. I just stared at the ceiling at the extraordinary drama that's taking place. Now, I'm older and sleepier now, so I did sleep the night after I read this opinion Monday night, but not much. It's very disturbing, very dramatic. The human effect on the American people is going to be very profound, and the drama inside the court must be searing. So with that, I will turn it over to Stuart, who will, I'm sure, has plenty to say on this. There's a lot to say.
Garrett, before I let you go, and you hear from Stuart, you have a piece coming out in the Washington Monthly on this, or has it already come out?
It's up on the website.
Okay, great.
Washington Monthly magazine. If you Google that, you'll get it.
Okay, thank you very much, Stuart.
Thanks, Jen. Thanks, Garrett. Yeah, I'm going to cover, I think, some pretty similar ground to what Garrett just talked about. My sort of lived experience with the issue of abortion rights and this topic is post Casey, but having taught this case or any set of cases from '09, I think during that entire stretch, there's always been this discussion about the possibility of Roe being overturned or Roe and Casey being overturned. And certainly a hot topic anytime there was a new appointment to the Supreme Court. And I sort of always had this thought during this entire time that it just wasn't going to happen, right? And it wasn't just stare decisis. It was actually this issue about that Gary identified about reliance, that as time went on, and as American society got more and more oriented around the fact of an existence of a right to an abortion, it just seemed more and more of a stretch to me that this would go away. Now, court watchers, those who sort of pay attention to this, knew that some ruling like this, the odds of this occurring this term were pretty good. That commentary had been going on for a bit, and that was the conventional wisdom. And yet I'll still confess a bit of surprise in actually seeing it in print and seeing this draft opinion, notwithstanding the fact that that many of us knew that this was a very likely outcome this particular term. The reason why I say that is, again, and I think others have talked about this recently, what we have was a constitutional right on the books for 50 years, and we see its withdrawal, its sudden withdrawal. And this is occurring against the backdrop of strong public opinion. That I think the Post just released a poll not that long ago showing that by a 2-to-1 majority, Americans favor maintaining the Roe decision. And so, as I think a number of observers have talked about, overruling Roe at this point, 50 years later, is something quite different than being opposed to the Roe ruling when it was handed down in 1973. To me, it's a much more dramatic act of judicial, I'll say judicial arrogance. And so I'll start with that. I have sort of 3 just general observations to make about this leaked opinion. And that's the first one. What stands out to me about this opinion is really a real sense of the judicial arrogance that seems like is apparent here. And this might be ironic to hear for someone who is critical of Roe, right? Because for those critical of Roe, it's often seen as the epitome of judicial overreach. But again, to reiterate the earlier point, to overturn a precedent that's this old at this moment in time seems to me a different matter. I think one could identify this ruling as in some sense a culmination of a trend that began arguably in the late 1960s, where we began to see a paralysis of our elected branches in the federal government that's gotten worse and worse over time. It starts with the greater presence of divided government, and of course, culminating to what we've seen in more recent years too, where we have Congresses and presidents that have a very difficult time, passing budgets and raising the debt ceiling and so forth. And historically, what we've seen when courts have had the opportunity to go in a very sort of aggressive way and to overstep is a dramatic backlash against them, where there is a generational loss of institutional legitimacy for the court. Right? We saw this for the court after the Dred Scott decision in the Civil War. We saw this for the court in the aftermath of the Lochner Court era. And who knows, this might be the opinion that leads us down a road that I think many have worried about for years now, where the court has stood out as this institution within our federal government that had a degree of trust and esteem that the other branches didn't. But I think it might be caught up in the wave of dysfunction within our federal government, and this is its sort of beginning of that process. To be a little bit more precise about my critique here, I'm not surprised, nor would most con law scholars be surprised about the presence of politics or political considerations in a ruling. This is to be expected. It's not unusual. We see this regularly from both conservative and progressive justices. So that's not a new thing. What's troubling for me is that Republican Party ideology showed up and was applied with seemingly little regard for the distinctive institutional position of the court. And so why do I say that? Because after all, the opinion has plenty of language in there talking about judicial modesty and the desire of this court majority to defer to the state legislatures. My thought is this, is that I find it very hard to believe that a justice who truly cared about institutional legitimacy and who was aware of the vulnerabilities of the court at, not just now, but just sort of generally as a branch that controls neither the purse nor the sword, that they would risk issuing a ruling like this and risk damaging the court's institutional legitimacy on the level that is quite plausible, I think, at this moment in time. One would expect that for those who ascend to the place of a Supreme Court justice, they would have some sense of institutional concern or political sensibility to have that in mind. But what seems to be the case, especially if this leaked opinion is going to be the final ruling, is that there are 5 votes that exist on this court that think that at this moment in time, in this heightened polarized political environment where there are constant discussions of democracy under threat, that this seemed like the right moment to overturn Roe. And that just seems like evidence of a judicial temperament that is not one that we should celebrate, or that would be admirable. Sort of related to that and related to a point that Garrett mentioned as well, what also struck me about the opinion was its tone, lacking, one might say, a kind of gracious acknowledgement of the concerns and arguments of the other side. You know, tone is a subjective thing, and so others might disagree, but I would suggest comparing this opinion to the plurality opinion in Casey. And to me, at least, the difference in tone is quite striking. And to a point that Garrett also raised as well, I find in the opinion the tone to be strikingly dismissive of the court's jurisprudence around gender equality and the arguments that many, admittedly not all, but that many Americans think and take seriously about the role of gender equality and its implications with respect to abortion rights. And one point that sort of suggests this is the fact that the court cites in the opinion to this opinion from I think it was 1974, Viscildig versus Aiello, which was a case where the court ultimately concluded that classification or discrimination based on pregnancy was not sex discrimination. So this case has not been overruled, but for those who are con law types, it's sort of thought about as a very anachronistic precedent, certainly not a thing that we would think about in this day and age post the VMI case as a admirable precedent to cite to. And indeed, Linda Greenhouse had a great op-ed in the New York Times the other day and made the point that the court itself has not cited to the Viscildig case since I think the mid-1970s in a sex discrimination case. But here it is showing up in this opinion, and I think illustrative of the fact that its author does not take seriously these doctrinal developments and precedents around gender equality that have occurred in the 1970s. And so showing up, I guess, in how this court majority is dealing with this issue of abortion rights. And I'll just conclude with one last thing, because I know the questions are sort of piling up. So I'll conclude with one last item about methodology and interpretation. It's just a more speculative point. But I think about this ruling and where we've come to here, and I wonder if this might be an indication of the fact that maybe Democrats and progressives in this jurisprudential space have made a mistake in moving away from a focus on living constitutionalism and trying to incorporate progressivism within methodology that seem more ascendant these days, which are textualism and originalism and historical inquiry. I'm a historical scholar, so I'm quite sympathetic to historical inquiry. But when was the last time any of us heard a Democratic appointee to the Supreme Court make a full-throated defense of living constitutionalism, right? There's a famous article written by Justice Brennan in the mid-1980s that talks about contemporary ratification, and I commend that article to you if you're interested. Well, when's the last time that any of us have heard a Democratic nominee to the court speak in those terms? And it's not the fault of those nominees. That sort of language does seem a little bit out of place. It does seem, that it would make one's life harder in getting appointed to the court and trying to do the good that one might do there. But by trying to engage in this debate about methodology and sort of conceding the ground, the rhetorical ground to originalism, I sort of wonder if that may have had some role in leading us to where we are. And I guess the reason why I say this is if we actually were to ask that majority of Americans why they do support the rule ruling and what's the basis of that, I don't think we would hear an argument based on originalism or what the authors of the 14th Amendment thought. I think what we would hear would be something that sounds pretty close to a living constitutionalist argument, that we have these guarantees in the Constitution. We don't invent them, right? They're there. There's a guarantee about equality that speaks for all persons in the 14th Amendment. What that guarantee may or may not have meant in 1868 does not limit on what it should mean today, right? So, as we think about what traditions mean, traditions don't need to be static as to what they were for specific rights at the 19th century. We should think about how those traditions should evolve and encompass changing circumstances. And indeed, the Roe opinion in Blackmun came in for plenty of criticism in this draft opinion. It is indeed the case that there have been a number of critiques about that Roe opinion from all sides across the ideological spectrum. But I would commend the analysis, and my students in common law wanted just heard me talk about this not that long ago, but I would commend the discussion about traditions that Justice Blackmun does in that opinion as well, because what he does with it is to link a set of traditions articulating rights at a broader level of generality and talking about how they're applicable to contemporary circumstances. To Justice Alito, that sounds like just judges making things up and having unbridled judicial discretion. But I would say that sort of task is inescapable in the task of being a judge and engaging in constitutional adjudication. So I'll stop there, and I think we should get into the questions.
Okay, great. Thank you so much, Stuart. And thank you again, Garrett and Stuart, both for giving us those impressions from the opinion. We have a number of questions, and I'm trying to organize these in my mind so we are sure to get to them. Some of them have to do with the implications of this opinion on other cases and other rights. And Garrett, you sort of began talking about this in your discussion too, but cases like McDonald v. Chicago came up here, Obergefell, of course, Griswold. Justice Alito does go out of his way in the draft to say that these, that nothing, we don't have anything to be concerned about with respect to these other cases. But like you say, Garrett, it sounds like at the same time, the rationale he articulates, seems to be poised to undercut a lot of these things. And so what's your take on how this opinion relates to what we might expect with respect to these other rights?
Well, the first thing to say is that McDonald doesn't really belong on this list because McDonald is a incorporation of a textual right from the Second Amendment and would be approached very differently, even putting aside the political predilections of the court's current majority, which is very pro-gun rights. Beyond that, I think that the opinion portends the possibility and indeed probability of very, very rapid doctrinal shift in a lot of areas, starting with abortion and spreading out. And this will become important when we look at cases about religious discrimination against same-sex couples, against people who don't want to recognize the equality rights of LGBTQ people, and so forth. The question is going to be going back to basically, did Sir Matthew Hale in Pleas of the Crown in 1750 say that that was a good idea? Well, we all know the answer. To ask the question is to answer it. I have to say that in the reassurance that Justice Alito includes, I heard a kind of eerie echo, a kind of image in my head of Prime Minister Neville Chamberlain holding up the Munich Agreement and saying, I have here a piece of paper signed by the German Chancellor that says this is the end of Germany's territorial ambitions in Europe. I don't trust it a bit.
I'll chime in too. I mean, on the one hand, the things that I would normally think about that would constrain the sort of overreaching of the court would be this thought around the political pressures around it and so forth. And this is what I think sort of a move by this court to say overturn Griswold or something would seem like a stretch. But at the same time, as I just sort of saying, this seems like this court has votes that are maybe a little less sensitive to these concerns around institutional political legitimacy. And so who knows, right? I mean, yeah, I do share that worry as well.
Okay, so thank you for that. Of course, one of the things that happened this week is there have been calls again for making a federal right to abortion through law, through legislation. And some have said, though, that the Justice Alito's draft seems to set forth a potential argument that the fetus has a personhood that would then make that kind of legislation impossible. What do you all think of that? Do you think this legislation stands a chance politically, legally? And then what about this personhood argument?
Stuart?
So yeah, this has definitely gotten a fair amount of discussion lately, and the Democratic effort. There's already some commentary about that, and I think Collins has already come out and said that the bill the Democrats are pressing is one that she would not be inclined to support. It's a little too broad. I think the issue the Democrats run into with some sort of quick legislative response is the filibuster concern in the Senate, and then of course all bets are off once the midterms occur and we see how the House might get reoriented as well as the Senate. So I suspect that the issue is going to be played out at the state level next. And this is a relevant point too for thinking about the political dynamics. One of the things that has been, a blessing or a curse, I guess, for the progressive side of this is having the benefit of Roe and Casey. And so as the argument goes, it has made it easier for abortion rights advocates to, not be as energized in the space as as opponents to abortion rights. But this script is going to be flipped right on the other side of this, where and there is an expectation, I think, that the energy will be much greater on the abortion rights side of things. For those who do listen to the Daily had an episode this morning and was interviewing a bunch of anti-abortion activists. And I think all of them accurately identified the fact that their lives are going to get a little bit more difficult on the other side of this, especially in certain states, because now there's something quite different about just being generally opposed to something versus actually having to put through policy. And so I think especially in certain states where there's political division, it's going to put certain abortion rights, critics of abortion rights and certain anti-abortion politicians in an interesting spot that they haven't been in for decades.
I will add to that I think the prospect of federal legislation protecting the right to choose is very dim. I don't think President Manchin would support it. There aren't 50 votes, much less 60. I think that at the federal level, the legislative action over the next 6 years to watch is going to be the clear desire, and the plans have already been drawn up for this. The bill's written, the sponsors are picked, of a federal ban on abortion, that there will be a nationwide ban on the procedure. And if the Republicans take over the Congress and the White House in 2025, I don't think there's any question that will move forward unless the political valence of the issue changes quite a bit. I think at the courts level, the real issue, and this is coming sooner rather than later, as Stewart alleged, is that there will be a push for a court decision that abortion itself is unconstitutional because the fetus is a person within the meaning of the 14th Amendment and cannot be deprived of life without due process of law. There were briefs, some fairly influential amicus briefs filed in the Dobbs case that said this is what we have to do. Here are the reasons why. To some very prominent and very influential conservative advocates are on board with this. I don't know what can be done to stop that, but I do think that the reaction, both electorally and in the streets, to this coup de main against abortion rights is going to be incredibly important. In the long run, I think what we learned from this episode and the tone of the opinion and what's happening is there's no real membrane between the general society and the court. It's all the same. And the justices on the right are Fox News watchers, basically, intellectually, if not, I don't know in person whether they watch or not. But they are using the same tropes. They have the same level of anger. They have the same contempt for people on the other side. That the political polarization in the country is as great within the court as it is anywhere else. And lastly, that the court really is no longer any sort of institution independent of partisan politics. It is simply a reflection of what is going on. That's a great loss. The loss was locked in before this, but it is made clearer by this episode.
Thank you. Okay, here's a question. Maybe the historian can help us with this. I'm struck by the absence of men as having any role in causing the pregnancy or having any responsibility for supporting the mother or the child, according to Alito. It's as if all immaculate conceptions, it's as if things are all immaculate conceptions, I guess, and puts all of the responsibility and none of the agency on mothers. Is there any common law basis for holding fathers accountable? Or is that up to the legislature, male legislatures in red states?
Stewart?
I don't think, Jerry, you might know a bit more about the history of the common law on this one, but I don't think there is such an obligation that's there. But I do take the point, and I think that's correct. It's for me, the issue about abortion rights is inescapably intertwined with gender equality. Granted, it's not a point that all agree with, and indeed there are many women who don't agree with that notion, but I happen to, and I think to the point raised in this comment is the hypothetical I throw out in my common law class every year. It's not to say that if we lived in a world where it was possible, or a universe where it was possible for the risk of unplanned pregnancy to be felt by all individuals, right, not limited to just one gender, would we think about abortion rights and the abortion issue differently? And I think the answer is clearly yes, right? It's not to say that every man's view would change if they would face the risk of unplanned pregnancy, but I strongly suspect that we as a society would think about the issue quite differently if that risk of unplanned pregnancy was spread more broadly than it currently is.
I'll add to that a couple of things. One is that to the extent there's action on the paternal responsibility area, it is actually on the other side of the issue. It has been the law in some states for a while and is becoming the law in other states now that fathers, even if unwed, and indeed even if they are assailants, even if they are rapists, they have legal rights to prevent an abortion, to bring a lawsuit against a woman who seeks an abortion or someone who provides her with one. So to the extent that this opinion is going to affect the status of fatherhood in the United States, it will be to empower it rather than to bind it closer into sort of any kind of web of obligation. Again, I wish I didn't think that was true, but there seems to be no mention in the draft opinion that this will mean states might have an interest in making fathers do X, Y, or Z. Contraception itself is not even particularly important, according to this opinion. And as Stuart says, we read this and say, well, if men could get pregnant, what would your answer be? And the truth of the matter is, I think we know. And the reason we know is that earlier this year, there was a very important shadow docket opinion striking down the Center for Disease Control's the ban on workplace, that they said you had to be vaccinated or tested in the workplace. And Justice Alito said, well, of course many employees don't want to do this. They don't want to do something that will change their bodies permanently. And so receiving a vaccine, which is something men would be required to do, is off the table because that changes the body. Bearing a child, which I'm told changes a woman's body permanently, is fine. And so I think that's all we really need to know about that.
I can confirm that it does change one's body permanently. So, okay. So here's another question. This one is very interesting to me as well. And this is something I've been thinking about a lot. What do you think will happen to full faith and credit if Roe is overturned and states that ban abortion have laws against seeking abortion in other states? And so this sort of also, we've been hearing now that maybe they're going to try to ban people from pregnant people from traveling to other states to get abortions. There's been talk about banning people, of course, from getting abortion pills or bringing abortion pills that they get in one state to a different state. What do y'all think about the idea that the states might try to legislate extraterritorially like this?
Stuart.
Yeah, no, I think the route where this would occur most prominently would be having legal mechanisms to prosecute those individuals who are seeking and obtain an abortion, right? And so I think I just saw this in the Times the other day that Louisiana is going ahead and pressing a law where I think, at least according to this reporting, is thinking about expanding its definition of homicide to encompass those who might actually obtain an abortion and so forth. I think that would be the mechanism to do so. And this would be, of course, obviously, other than just incredibly disturbing, a market shift, I think, in the approach of anti-abortion activists, which up to this point or until quite recently have been very focused on making arguments about limiting and restricting abortions in the name of protecting the health of pregnant women and so forth. But instead, to sort of go into this territory to start prosecuting women that are obtaining abortions is going to be a dramatic shift, I think, from what we've seen recently.
As far as traveling interstate, I think if I were an abortion advocate, I would like to see the blue states passing laws that purport to do this to people who bring firearms into the state. Or say if someone goes out of California and buys a gun, they can be sued. I think that the only reason that states or the court would back off these laws is to realize it's a very dangerous precedent to set. Other than that, I don't know. I think that, basically, this is, and maybe I should just hang up, but basically the message of this opinion is there is no precedent. Everything's up for grabs. We'll do what we think is right. And it's not a reassuring message looking at the faces that sit on that bench.
Okay, so that's interesting because I was just reading something by Jeannie Gerson today about how the leaker themselves sort of disregards precedent too by going ahead and just not following institutional norms around secrecy. And so we have a couple of questions here about the leak. One is, how does one go about leaking a Supreme Court opinion? Are leaks going to become a new norm in the judicial branch? And a related question, can you give your thoughts about the timing of this leak? As we know, the draft was written in February. Uh, it wasn't leaked in February. It's leaked now. Presumably, other drafts have been shared, so this is not even the what's maybe in play at the current moment. Any thoughts y'all might have around the motivations of the leaker or the mechanics of this leak in the first place, or what it portends for the work of the court down the road?
I'll just say one thing real quick, because Garrett definitely knows way more about the inner workings of the court than I do, sort of being a very, very notable court watcher. But I'll say really briefly, we've seen symptoms of this sort of degradation of established political, civic, constitutional norms over the course of the past several years. And I think this is just evidence of the fact that those larger trends we're seeing in our broader society and government are coming to the court. And the irony for me, at least from sort of my lived experience in thinking about how these issues have evolved, is thinking about how a movement around legal conservatism was one oriented, at least in theory at the beginning, right? A concern around, I think, a reaction to the war in court and the uprooting of precedents. But I think, Garrett, to your last point, what we're seeing is the sort of rhetoric and political energy of a movement that was originally oriented around conservatism behaving in a very non-conservative way, right? I mean, this is the opposite of conservatism and sort of being respectful of precedent and careful and deliberate evolution of the law. But anyway, with that, I'll turn it over to you.
Well, I will say a couple of things. I have no insight to share about the timing of this leak because, as I said, none of the scenarios that people have proposed make any sense to me. That doesn't seem like a rational thing for people on either side to do. And so I think someone somewhere, either within the court family or peripheral to it, was so reacted so emotionally, and the atmosphere inside the court must be so fraught that they did something irrational. Because I don't see whether it benefits either side for this leak to take place. But I will also say, and I wrote this in the Washington Monthly, that this court is not the court we grew up with. This court, and by which I don't mean it has different people, I mean it has a different function in our system. It is now a part of the Republican Party governing apparatus. It is part of the permanent, you want to talk about the deep state. This is part of the Republican deep state. They've accepted that role, or at least 5 of them have. And that being the case, of course we're going to see more leaks. The political branches have to deal with leaks all the time. They're a tool that are used to achieve political ends. The court is now a political body with an explicitly partisan divide. And as far as I'm concerned, you live by politics rules, you die by politics rules. Get used to the leaks.
Well, that's kind of disturbing, because you could see that you're right. It's not the court we grew up with. And at the same time, it's a real loss if they weren't able to do their, if they have to change the way they do their work in terms of having to get used to leaks. But perhaps you're right. This brings us to a question.
Can I just really quickly on that point too?
Oh, yeah, please.
I thought about this in the broader sense as well about, this point about the overriding influence of partisanship. There used to be this notion, right, that of institutional integrity, right? That no matter what party you were a part of, there was something. This is the old Federalist Papers notion. The ambitions of the individual tied to the incentives of the office. And that was our working presumption for all our branches. Right now, we're seeing that with Congress, right? This is kind of a longer running thing, but I think members of both parties in certain respects are willing to let the prerogatives of that institution degrade in favor of achieving political aims as they're tied to a president that's of their party, if they have a sitting president that's of their party. And yeah, I guess we are seeing something similar with respect to the court as well, that the concerns of the institutional legitimacy and prestige of that institution may take a sort of backseat to this larger goal of achieving clear, discrete policy goals.
Yeah, and I'll say, I think Stuart's absolutely right, but I'm going to say something I never in my life thought I would say until quite recently. And that is, I really feel for John Roberts.
Yeah.
John Roberts believed all the myths that judges were independent. He thinks he has been independent. He has not been the same kind of movement conservative as the others because he believes in the court. And what he's finding now is that his so-called allies on the right, all of them, never believed that at all. They just wanted the results they wanted, and they would do anything to get it. And they have cast him aside just as surely as they've cast the three liberals aside. And it must be a very, very difficult time for someone who, yeah, go ahead, Stuart.
100% agree with that. You know, I like most other sort of, you know, progressive minded con law people, I kind of scoffed about hearing, you know, umpires calling balls and strikes during his confirmation hearings, and, you know, his opinions in Shelby County and parents involved and so forth, you know, much to be annoyed and critical of. But at this moment in time, I do feel a real respect for, I mean, this is an individual who seems to really take institutional role and institutional integrity seriously. And frankly, it's really missing, I think, in other parts of our federal government as well. So when we see it, I mean, I do respect it and appreciate it.
And let's remember that one of the most courageous moments of resistance to the Trump administration when Trump was in office was when the Chief Justice, for the first time in American history, directly responded to a sitting president's criticism of the court and told the president, basically, don't do this. Don't try to intimidate us. I never would have imagined a Chief Justice would have to do that, and I never would have imagined that John Roberts would. But it gives you a picture of the desperation that he and the institutionalists around the court must be feeling as they watch this new majority slash and burn through precedent.
Yeah. Yeah. And of course, you know, them being on the court for life, you know, this is going to be their lifetime workplace. It's not like, I mean, they have to work together. And that brings us actually, I mean, maybe this has been answered, but just the Supreme Court justices always fervently claim that while they disagree, they have tremendous respect and liking for their colleagues. I'm reminded of Justice Kagan, you know, being really nice to Brett Kavanaugh when he joined the court. Could this extreme and nonsensical opinion, and I think the draft opinion he's talking about here, threaten the collegiality in the one branch of government where it still seems to exist? Sounds like y'all are saying you think so. Yeah. All right. Okay. Another question. What do you make of Justice Alito's treatment of the balance of the 14th Amendment other than substantive due process? Question resonate with you?
I'm not quite sure. Yeah.
Yeah, I don't know where that's going. I think this is a substantive due process opinion, right, Stuart? And that being the case, you know, the other clauses of this multi-clause amendment don't seem to me to be implicated.
Okay. All right, so some of these we've already touched on, so I just want to make sure I'm looking at everything. Are you all familiar with this Brackeen case on the ICWA that's coming up? Okay, so there's a question here. Thank you for speaking on this today. As a Native woman, I'm also very worried about the upcoming Brackeen case on ICWA. I'm already not very optimistic about the outcome, but given Barrett's comments about the supply and demand issue of adoption, how will this Dobbs opinions play into the analysis of Brackeen?
Well, I think it's very interesting. And if to the speaker, I would recommend, if you haven't, to go back and listen to the audio of the Indian law case that was argued last week. And regrettably, I, at this moment, can't call the name. But this is a question of whether, you know, the court has already held that the original treaty establishing the Muskogee Creek Reservation has not been abrogated, which means a huge percentage, nearly a third of the state of Oklahoma, is Indian country. It doesn't take away the title of owners, but it is now under the jurisdiction of the Muskogee Creek Nation. And the court is considering, you know, Oklahoma is absolutely outraged about this because they say that they want to have their police have jurisdiction inside the reservation, which local police do not, absent congressional authorization. And in that argument, Justice Gorsuch, who is the only real sort of intercoastal Westerner on the court, was absolutely ferocious. And I've seen this happen several times before in Indian law cases about these treaties are promises. Why does the white man get to break his promise? really berating the lawyer for Oklahoma over this. And so I think that the lineup may be scrambled, and we might be looking at 5-4 in that case, especially since Oklahoma has not been entirely forthcoming. I think that the Brackeen case, which concerns the Indian Child Welfare Act, is going to be a really titanic struggle because Justice Alito, who, as we know, has a certain mystique about adoption, has written already that he thinks the Indian Child Welfare Act should not be interpreted to keep Indian children from good homes, by which I think he means non-Indian homes. But Justice Gorsuch is very defensive of the prerogatives of the tribes. And I've actually seen Justice Gorsuch tell Justice Alito on the bench, why don't you shut up about this? You don't know what you're talking about. Not in those words, but really, it was the most direct slap I've ever seen. And how that's going to play out, I really don't know. But it's right to be concerned because one of the aims of the conservative legal movement from day one has been to do away with tribal sovereignty, to open Indian lands to resource exploitation by the states. And this is not only an important step in sort of actually destroying tribes by attacking their population base, but it also is an important step in destroying tribal government, destroying tribal sovereignty, and really taking the Indian lands once again. So your questioner is well advised to watch it, but it's going to be very interesting. It's not going to be as simple as the lineup won't be as simple as the abortion case seems to be.
Thank you so much. Do you want to add anything, Stuart?
Oh, no, I haven't been following this line of case, so I'll defer to Garrett. Take on it. Yeah.
I'm hoping that we're going to be doing a webinar to the questioner on this very case in the near future. Okay, so one more question. This is a court reform question. This is something we've been talking about for a while, and it's good to sort of bring it up again. Do you think that this whole situation, this leak situation, can give new life to this argument for like increasing the size of the Supreme Court, given that people may feel they've been lied to in the confirmation hearings by various of our newer justices who all said that they had this great respect for precedent and specifically for Roe. So the precedent of Roe. What do you think? Do you think that that court expansion is a possibility?
So I'll offer a couple of thoughts here. I mean, I think, ironically, perhaps the pathway for reform of the court is probably going to lie through a pathway where its luster and legitimacy takes a hit, right? Because the stakes of the reform are going to have to feel different than where they are now. And so maybe as the court's legitimacy declines within these certain sectors of the voting electorate, maybe some possibility of reform becomes more plausible. I'd offer two things, one of which I think is just a broader general hope, but second, something that might speak to one of these reforms, which has been the idea of term limits. There's something very odd, and apologies to my common law students, they've heard me say this already before, but there's something that seems very odd in a democratic system where we are so fixated on these 9 individuals when they happen to choose to retire, when someone happens to pass away unexpectedly. And it sort of invokes how like life must have felt like under an absolute monarchy or something like that. And it just seems totally irrational. And so if we could ever get to a system where there was a sort of more set term limits of, and it could be an extended period of time to understand that this position is one that's meant to be outside the boundaries of regular electoral politics. I think that would be much more ideal, provide a greater deal of rationality and regularity than the current system that we have. But my more general point is, we seem to be in this kind of dysfunctional, that's not quite the right word, but this dysfunctional pattern where the stakes keep getting high enough where we keep bringing, as we've talked about, this court closer and closer to the dysfunctionalities of electoral politics. And I think it is a general matter, a positive way forward would be one in which we would just de-emphasize the importance of the court, right? That this sort of culture of celebrity around our favorite justices and how we identify their personalities and this is an illustration, I think, or symptomatic of a democracy that is not functioning well, because I think it's implicitly admitting that we cannot achieve the policy goals that we would like to see through the elected branches. And so we're going to pin our hopes on this one individual who will hear our compelling rational arguments and just give us what we want. I'd like to think that the way out of this pattern will be one in which we somehow see a revitalization of Congress and the president. But for con law nerds, if you remember the Youngstown case, Justice Jackson talking at the end of that concurring opinion, basically echoing words that are very relevant today about wishing Congress would step further into this process and not just cede its authority to the president. So I don't know that it's likely, but that would be my hope.
I think that court reform is not on the table during this Congress, during the remaining period of this Congress. President Manchin would not permit it, and the filibuster would be in the way. I think that this is going to sound really paradoxical, but I do think the prospect of court reform by expansion is going to remain on the table, because I would anticipate that if Republicans get control of both branches after 2025, they will expand the court. They will give themselves 3 or 4 more seats. And that would be, in the short run, quite disturbing. In the long run, a number of very smart people observing this, who worked with the President's Commission on Court Reform, have said that would be great, because then when Democrats get in, we can expand the court. Eventually, the court gets to, what if the court gets to be 20 people? So what, right? We have circuit courts that do that. They'll hear cases in panels, and have in bank, and the courts know how to do this. But the point is, if you start expanding the court, even if it's done for base motives, what it does do is make each appointment less important, right? Remember when Ginsburg died, and this is World War III, because one octogenarian cancer patient died. The world comes to an end. If we had 20 people on the court, that wouldn't be the case. So the basic prospect is for no change in the short run, and if the Republicans decide after 2025 that this is a priority, I would expect you to see the filibuster depart the building very soon after, and that might be a good thing too.
Okay. Well, thank you so much. I wish we had more time. I know I speak for everyone. I say how grateful we are, Garrett and Stuart, for y'all sharing your expertise with us today. Thank you so much for everyone who's watching. We're going to post the recording of this soon, and I very much appreciate everybody's comments and questions. This is not going to be the last time we convene to talk about these important issues. So thanks very much. Have a wonderful rest of your day, and happy Friday.
So long.